Hello, everybody. Welcome to this seminar, part of the III Inequalities seminar series. I'm Francisco Ferreira, the III. Very happy to welcome today Professor Tarun Khaitan, who is Professor of Public Law at the LSE Law School and an honorary professorial fellow at Melbourne Law School. Well, so Tarun would prefer for there to be clarification questions only during the talk. Okay, with those more substantive discussions, if we could leave them to the end, please. Tarun, thanks very much. The floor is yours.
Thank you very much for inviting me. I'm very grateful to the III for having me here. I am sharing with you. Okay, so I hope you can. Awesome, it's working. Right. So this is a project that it began sort of 10 years ago, and it's a paper I'm sitting on for a long time. So honestly, if I had something to present, I thought it would be a good time to revise this half-written quarter-written paper. So I'll give you a bit of a biography of the paper. My early research was on discrimination law theory. That was my PhD. And sort of how old I am now hit home when a journal asked me if they wanted to do a 10-year celebration of my book in a special issue. And I was like, well, that's how long it's been. So the book is called A Theory of Discrimination Law. And the book was based on a comparative study of the practice of discrimination law in about 5 jurisdictions from the North and the South to propose a general account of what the law is trying to do. And in the central claim, it was a synthetic work in that it tried to show why the two tribes in discrimination law sort of process versus substantive, formal versus substantive, group and individual, all these divides existed because they were responding to different dimensions of the law, and that a holistic picture only emerges once we take into account in the correct manner all of these things. And then I was approached by a political party in India, because India still to this day does not have a comprehensive anti-discrimination law. There are various fragments in various parts of its legal structure, but no comprehensive law. And so they wanted me to draft a bill. This was a request by a state, and I did the work, and then it became politically unviable for them to proceed on it. Eventually, the bill was presented by an MP, an opposition MP in Parliament in 2017. It did not go anywhere except perhaps discursively. But that process of drafting the bill is where this project came out of. So I spent about 4 years making various trips to India, doing lots of workshops with activists, with lawyers, with academics, with affected groups, just to discuss ideas, to explain what I know and learn from them, what they know. And it was very sort of enlightening, in part because, despite indirect discrimination not being a recognized concept in India at that point, activists quickly understood what it meant, and could come up with examples of what are the forms of indirect discrimination in that context. And so all the concepts that I explained from my theoretical framework was easily transferable for their experience. But then they started asking a lot of questions about the gaps that the comparative framework had, which would not address their lived realities. And the most abiding of those gaps was, well, this framework is restricted to the state and the market. What about the family? And my instinctive response was, no, discrimination law can't get into the family. That's too far. And then one of them said, well, if you can't engage with discrimination in the family, then this bill is not worth the paper it's written on. And that is when I started thinking about the challenge of discrimination in the family. And whether this instinctive reaction of family is not an appropriate site of discrimination law was correct. So this paper is probably one of my last remaining things I might write on discrimination law. And it's exploratory, it's experimental. But here's some data. Forgive the American character of the data. It's just more readily available because of the scholarly attention the US gets. But a lot of these studies in the US especially conclude that LGBT youth report elevated rates of emotional distress, symptoms related to mood and anxiety disorders, self-harm, suicidal ideation, and suicidal behavior when compared to heterosexual youth. And that compromised mental health is a fundamental predictor of a host of behavioral health disparities evident among LGBT youth. Example, substance abuse and dependence. In a meta-analysis by Marshall et al. In 2011, it was reported that sexual minority youth were almost 3 times as likely to report suicidality. It's very distributed. I should have given the one.
Tarun,
These investigators.
Tarun, sorry, can you speak up a little?
Oh, sure, yeah.
Yeah, thank you.
Mumbling. These investigators also noticed a statistically moderate difference in depression symptoms compared to heterosexual. A CDC survey during the pandemic found that 46.8% of LGBT adolescents seriously considered attempting suicide over the survey period compared to 13.6% of their straight peers. 26.3% actually attempted suicide compared to 5.2% of their heterosexual peers, and that these differences were statistically significant. Now, this is not just an LGBTQ phenomenon. It is based on all those groups that in my book I describe as non-national grounds of discrimination. Gender, marital status, age, disability, pregnancy. On all of these markers, so I've not marshaled the evidence here, but I call them non-national grounds because these are grounds that tend not to define national groups, as opposed to grounds such as race, religion, language, that are at least potentially national. And the key distinction between non-national and potentially national grounds is that families tend to be homogeneous with respect to potentially national grounds. So we see less intra-family diversity in relation to race, religion, language than we see on these grounds. So these grounds are more salient when it comes to intra-family discrimination. Not only do we see people with different characteristics along these grounds within the family, we also see that these grounds themselves are the reasons for many forms of discrimination within the family, especially against adolescents, but not just adolescents. They can take many forms: violence, abuse, neglect, coercion, policing relationships, enforcing gender roles, enforced disowning, dehoming, disinheriting, detaining, denying access to housing, education, mobility, or differential access to all of these things. Examples would be sending your sons to a better school than your daughters, and so on. So that's the problem. And as I said, while I do not have enough evidence, I hope that it seems like a plausible claim to you that these problems are pervasive in all societies to different degrees. Compare that with the traditional scope of discrimination law, and there are two key features. One, that discrimination law only regulates relationships in the state and the market. In different jurisdictions, the starting point was different. In the UK, discrimination law started with regulating the market and was extended to the state. In the US, it started with the state and was extended to the market later. And different countries have different historical trajectories. But broadly, discrimination law in most jurisdictions is restricted to these two spheres. The family is categorically left out. It's simply not included. And one way to understand the law's silence or non-extension to the familial domain is to assume that it presumes the family to be too private to regulate. So this is an attributed justification to law's silence attributed by me. That reason why the law does not get into the family domain is because it irrefutably presumes the family to be too private for discrimination. Now, I'll say a bit more about this. All of us intuitively accept that not all forms of discrimination that are morally wrong should also be legally prohibited. If I decide that I will not cultivate friendships with people from a certain race or a certain religious group, that makes me a terrible person. But I think most of us would accept that the law forcing me to diversify my friend circle would fundamentally undermine what it means to be a friend, fundamentally undermine the institution of friendship. And therefore, while it is morally reprehensible, it's probably not wise for the law to get in there. Having said that, I mean, that's not the topic today, but I do want to say that I don't think even in domains of dating and relationships and friendships, there's a categorical exclusion of law. It's one thing for the law not to tell you who you should date. It's quite another for the law to prohibit dating platforms from making race or religion salient or permitting racially exclusionary preferences being articulated, right? But that's for another day. Very much in continuity with what I'm going to say today. The second feature of this law's silence with respect to family is that it has a disproportionate impact on certain protected groups. So discrimination law's failure to extend to the family disproportionately affects the disadvantages women over men, girls over boys, queer adolescents over straight ones, able-bodied children over disabled ones. And this is, for those of you who know discrimination law and maybe some others, paradigmatically what we call indirect discrimination. Indirect discrimination is when a rule has a disparate impact, a disproportionate impact on a protected group, even if the distinction does not explicitly track that group identity. Does everyone in the room know indirect discrimination, or should I explain it a little bit? Okay, I will tell you. So the idea originates in an American case called Griggs and Duke Power Company in the 1970s. Duke Power Company was a power company that used to have a whites-only employment policy for certain supposedly low-skilled jobs. When the Civil Rights Acts are enacted in the US, it changes its policy for these low-skilled jobs from whites only to graduates only. Right? Given the social demographic of the region where the company drew its employees from, the effect of the graduates only policy was to exclude most non-white candidates. Okay. Now, at the trial level, and this is important, the claimants, the excluded claimants, were not able to establish that this graduates only policy was basically a ruse, that it was proxy discrimination, that they were using it with the intention of excluding non-white applicants. Had they managed to do that, this would be an easy case of racial discrimination. Right? So the court had to proceed with the assumption that this was a facially neutral policy, right? That there was no intention to exclude any racial group. In the American Supreme Court, in a famous decision on Griggs, came up with the idea that even if the policy is facially neutral, it does not on its face exclude a racial group, nor is it intended to do so. If its effect is to exclude a protected group, then it needs justification. So you need to show why is it that your power company need to have a graduate-only policy. On the standard of, it came up with a standard of business necessity. Now, of course, in this case, the power company had no justification because it had for decades operated, hired people for this job who were not graduates. Right? So suddenly what changed? Nothing had changed in the nature of the job, so it could not show that the candidates needed to be graduates, and therefore it failed the justification test. Soon after this judgment, Roy Jenkins, the British minister, was visiting the US. Somebody told him about the case. As it happened, he was also tasked with drafting the Race Relations Act, which would become the Race Relations Act of 1975. He comes back to the UK and enacts this idea of disparate impact into British law as indirect discrimination. And then it is from UK law that the concept first travels to the EU and then around the Commonwealth world. So South Africa, Canada, Australia, India, Hong Kong, everybody borrows the idea, calls it indirect discrimination, and it's fairly stable phenomenon in discrimination law that you don't need an intention as long as what you're doing disproportionately affects a protected group. But the bar is less harsh. So unlike direct discrimination, which is either unjustifiable or can be justified under very limited circumstances or for very stringent reasons, indirect discrimination in most cases can be justified if you can show that it is a proportionate means of achieving a legitimate aim. Okay? So, and this has been ubiquitously used, including in cases of legal silence. So you don't need to actively do something. Omissions can also be indirectly discriminatory. So an omission to have a ramp, for example, and things like that. Okay, so the claim I am making here is that if you accept the empirical proposition that discrimination within the family is a thing, and it is usually directed against groups that are traditionally protected within discrimination law, then it follows that discrimination law's silence on family or its non-regulation of family is itself indirectly discriminatory against these groups. In other words, the claim is that discrimination law itself is discriminatory, at least presumptively discriminatory, in not extending to the family. Okay? So, is this justified? Because that is the next inquiry in the law, right? Its silence disproportionately affects certain groups, but there may be good reasons for that. Do we have good reasons for the law's non-application to the family? And in the rest of my presentation, I'm going to show why we don't have such good reasons. So obviously at the heart of this lies the public-private debate. The public-private distinction, which I'm sure you all know, the feminist critiques of the distinction. And by the way, the distinction was initially used to, and is still articulated, to claim that discrimination law's regulation of the market goes too far. Because on the classic liberal public-private divide, the market as well as the family are both on the private side of the divide. Right? So discrimination law is curious in a sense that unlike liberal constitutional law, that broadly still, at least the dominant forms broadly comply with the classical form of the public-private divide, which means that the state is the duty bearer and individuals and companies in the market and the family are rights bearers. That's not how discrimination law thinks of the divide. The market is switched from the private to the public domain. And in my book, I had tried to make sense of this, not by accepting the feminist arguments of giving up on the divide, but by taking the arguments seriously to recast the divide. And this is what I had done. I had argued that the problem is not in the divide itself, but in imagining it as two binary boxes. And that the divide is better understood as a spectrum rather than categorical binary division. At the public end of this spectrum is the state doing the most public thing possible, which is making general law in its legislature. At the private end of the spectrum is a private individual sitting alone in a room, deep in contemplation. There are many different possibilities in between, which lie across the spectrum in a dynamic fashion. More importantly, I had argued that the spectrum is not spatial. So it's not correct to imagine the public-private divide in terms of domains of human activity, just state, market, family, and so on. What matters for publicness is power. That is at the heart of this divide. And there are two forms of power that we should care about: power over and power to. The more power, relational power, we have over other persons, the more public we are. And the more power we have to control means of production and opportunities essential to a flourishing life, the more public we are. So this spectral way of understanding the public-private divide distinguishes between meta and X from you and me, whereas the classical divide would put us both in the same box and apply presumptively the same constitutional rules. And this was just a chapter in the book and not particularly well developed, but in hindsight, I think it has the germs of an account that can help us to understand the family, because it is precisely this concern of discrimination law with power differentials that manifests itself within the family as much as in the market and between the state and its citizens. And most importantly, and I'll move quickly in the last few minutes to the more policy aspect of this project. Most importantly, we have done this in the context of domestic violence. We have so much learning on how the law can navigate. It's complicated. I don't want to deny the difficulty in juridifying familial relationships. I don't want to deny that there is at least a potential cost to family relations, just in the same way that juridification of friendship would have costs to the idea of friendship, right? So I don't want to reject those concerns out completely. But the law has managed to walk a fine line in the context of domestic violence and marital rape. And I think at least one strand of family discrimination can benefit from looking at how the law has come to deal with domestic violence. So what is that strand that I'm particularly interested in exploring in this paper? It is what Arundhati Roy in The God of Small Things called the love laws. And she defined the love laws as laws that dictate who should be loved and how much. And the goal of these laws are to ensure social segregation determined by our ascribed identities: caste, religion, gender, sexual orientation, disability, age. There is all of these identities are descriptive in many societies in how one must relate and to whom and how much. And they're enforced primarily by the family, sometimes by the clan and the community as well. And they disproportionately affect groups defined by non-national identities. So the conceptual application part of this paper shows how can satisfy the spectral publicness that I have identified in having enormous relational power, especially in relation to young adults and adolescents and the elderly sometimes. Okay, so this is the final part. Believe the law's silence is unjustified, at least in relation to the love laws, because a liberal state has strong reasons to enact proactive measures to resist the love laws enforcement for liberty reasons as well as for equality reasons. And that one can imagine certain types of legal interventions that do not fall foul of the public-private divide. And at the proportionality inquiry stage, a blanket refusal to regulate is unlikely to pass muster, because proportionality requires you to do what is necessary for the job, doing nothing is unlikely to satisfy that. So here's what the draft Indian Equality Bill came up with. So this is the more policy dimension. It created a new offense of discrimination called segregation, obviously relying on the history of segregation as a discriminatory offense in the United States and South Africa and so many other countries. And the offense was to prevent individuals or to punish them for interacting with, marrying, loving, living with, cohabiting with, working with, becoming friends with other persons based on a protected characteristic. And the remedial dimension, which is probably what gets liberals most worried, drew upon domestic violence acts, domestic violence laws, which are non-penal. And by being non-penal, they actually facilitate better implementation because often women do not want their husbands to be criminalized, even husbands who beat them. They're also, to some extent, proactive or preventative because criminal legislation requires the state to step in all guns blazing when things have gotten out of hand, when it's in some ways too late. And we know that at least in some states with functional social care provisions, the state does step in to remove the child from the family and things like that. But discrimination law can permit a calibrated approach, a calibrated intervention much earlier in the process. And these they could be injunctive when there is real risk of violence or harm. The person can be removed for their own protection from the family and presumably at their own request. There's a whole swathe of other possibilities that the law can envisage. Now, of course, law is a limited tool when it comes to discrimination, and especially when we are thinking about adolescents, there's going to be a huge implementation gap anyway because the number of young people coming forward against their own families will be limited. Having said that, discrimination law performs a norm-setting function in society as well. It has a strong expressive role. We have to only look at the history of the last 30 years and the enormous normative change led by the law on social attitudes to queer people has happened in many societies around the world. Of course, I'm not a social scientist, so I don't know why the law has failed so dramatically when it comes to racial and religious discrimination. So successful in norm setting when it comes to LGBTQ and disability discrimination. I don't know, maybe you have some answers. But anyway, I think that both for its agenda norm setting purposes and for the limited intervention it might make for certain, even a small set of people, this is worth exploring. But I'll stop there. And as I said, this is very much a work in progress. So any comments, thoughts, questions, reading suggestions are very welcome. Thank you.
Great. Thank you very much, Tarun. That was really interesting. So we have time for some questions, quite a bit of time. Are there any? Yes.
Hi, Professor. I had a question about the last part, where you describe certain ways of regulating the conduct that is regulated and distinguish it from the method of regulation. I wonder how the method of regulation or generally the supporting architecture of discrimination law norms might reasonably be said to be a part of discrimination law, because it seems that the method of regulation in some ways is the supporting architecture properly in a conceptual sense, not part of discrimination law, perhaps because it doesn't fulfill the four essential features you outline. And that's something that I've been thinking about your theory of discrimination law more generally. To what extent can we reasonably say that the supporting architecture, the method of regulation, is part of discrimination law? And then there's some Mariology involved there as well, wholes and parts.
So is this a query about remedies? What remedies discrimination law can grant is not constitutive of what discrimination law is. Yeah, I think that's right. I mean, unlike tort law, which is where damages as remedies constitutive of what tort law is, I don't think that discrimination law or punishment is constitutive of what criminal law is. As you know, I don't think that what discrimination law grants or is able to allow as a remedy is constitutive of what discrimination law is. I think a whole swathe of civil possibilities exist. And yeah, I think I stand by that view.
Yes.
Yeah, Professor, thanks for your talk. This was really, really helpful. I had a question with regards to your enforcement by family clan question. And I was wondering to what extent in family law or within families, a lot of this discrimination is not even acknowledged as discrimination. So it's not labeled as being discriminatory. It's confused with love. And do we see similar versions of discrimination in public sphere where people don't accept what's the treatment which is being meted out to them as being unfair? And how do we try to even start overcoming this barrier in the first place?
Yeah, that's a great question. So, as it happens, I've just been reading Bell Hooks and her exploration of when love becomes abuse in the family. But I think there might be parallels in the public domain. So, as you know, discrimination law, even indirect discrimination liability is action-based, act or omission-based, right? You have to show a rule or its omission that results in disproportionate impact. Simply pointing out a state of affairs without a causal mechanism or a correlative mechanism wouldn't do. So you can't just say, well, LSE does not have enough female professors. That would not ground a discrimination claim. You'll have to show some LSE policy that has at least a plausible connection with that outcome, right? So in this, I think, obviously, is the law's failure to acknowledge structural power, right? What Stephen Lukes would call structural power, which operates but need not be exercised in the capitalist system. I don't think courts and law can solve that. That requires political action at a fundamental level. So maybe something similar, some similar re-articulation means. I'm not a family lawyer, so I don't really know to what extent family law engages with discrimination within the family, if at all. But I do know there's a strong understanding of parental rights, especially when it comes to education of children. And of course, there have been inroads made, like compulsory education in some countries, in some jurisdictions, but I'm not really aware of whether any of these concerns have been articulated and understood in family law, because if they have been, then maybe discrimination. I mean, I don't think discrimination law needs to solve this problem. As long as the problem is being addressed in some other area of law, I'll be happy with that. But to the best of my knowledge, I don't know of any dimension of family law that does that.
Thank you, Tarun. I had one quick comment and then perhaps a question that would help me clarify the scope of kind of the practical implications. So the thought I had was trying to make it kind of more palatable as a reform option. One thought I had was that there is a principle of non-discrimination that is reflected, for example, in things like intestate succession, right? So if there's no will, there is a principle of non-discrimination. So I wonder if some of that kind of technical, but reflects broader, I think, values. And then the example that was I thought of, as you were talking, I thought of domestic violence, and so it was really helpful to see that. And I think, obviously, you would know the context when the bill was passed in India, but I wonder whether some of the discussions were, oh, what was happening there is we have law that doesn't stop at the family door, right? So violent sexual aggression would be punished outside the house, so why not have it inside? Are there, in the kinds of the reforms you envisage, would that be something similar to that? So we bring in some norms inside the family, so we enhance child neglect laws? Is there other categories that would be introduced, or other protections that would be introduced specifically within the family? So is it just an extension? Is it something newer that this would offer?
Yeah, so that, given the exploratory nature of this project and the lack, I mean, my imagination is itself limited by the legal frames that we have. And in the case of domestic violence, it's typically the case that by the time a person approaches the state, things have become intolerable. And there, to the best of my understanding, domestic violence laws seek to ensure a basic standard of living and personal security, right? And access to funds, property, maintenance, all of that. Now, those things would be important in the family context for dependents, whether they're very young or they're very old. But discrimination is slightly more complicated than violence because there's a whole spectrum of possibilities when it comes to discrimination. And it's harder to determine what is the point at which the discrimination merits breaking the familial bond by the state, right? And when it should try to intervene within the family. Also, enforcement within the family is extremely hard because you can't appoint a constable to start living with the family. So these are all real questions. I don't want to dilute their significance. The claim is that at least in the context where discrimination is of the same character, is beyond a certain level, that state intervention can be justified. And so I think not sending your daughter to school where you send your sons is in a country that does not mandate primary education or secondary education, I think would be a clear breach. Sending her to a cheaper school, that's a harder case, right? And so there will be lots of difficult issues here, but I think what I'm trying to change is the question whether to how. I think the question is not whether the law should intervene, but how and to what extent. And that is a proportionality-led inquiry, and I don't have all the answers, but I think that is the right question to ask. There are some questions online as well. I don't know if or you want me to just read them out and look them? Okay, so there's a question. Which starts with a praise. Thank you. Is Professor Khaitan treading a thin line between benign and malignant, his friendship example, or trying to import the vertical power relationship due to heteronormative framework, domestic violence and marital rape, to attribute animus as a criterion for discrimination, hence protect the individual? No, so I think within the family, an animus-based approach, sort of discrimination as intentional exclusion or disadvantaging of certain groups, it did not work very well, even in the case of the state and the market. Right? It's extremely difficult, if not next to impossible, to prove a discriminatory intent. And the law has moved beyond that a long time ago. I mean, the discriminatory intent or prejudicial intent is always sufficient, but is never necessary to show discrimination. And I think in the familial context, showing a discriminatory intent will be even harder, especially because of claims and sincere claims of, I just love my daughter and that's why I don't want her to marry this person and so on. So I think it'll have to be effect-based rather than intent-based. Yes, you can follow up, please, Surendra. Do you want to just turn up your mic and ask your question directly? I think they're typing. Yeah.
So while they're typing.
Oh, not allowed to unmute. Oh, I've changed it. Okay, so I think you've just been given the permission. Should we take another question from the room?
I have a question. I had actually two questions. So one, I thought it was really interesting, thinking about discrimination law in the realm of the family. And as you did, I was thinking of other realms in which law already does intervene. And obviously, domestic abuse, violence is one of them. Neglect of care also, right? So it's not just, again, actions, but omissions. If you don't feed your baby for long enough, you'll get in trouble with the law. But then one that I thought was interesting, and I wonder if you didn't talk about it, but it's almost like discrimination is around inheritance laws, right? I think in many places, it's very hard to exclude your daughters from inheritance. You can, but it's more complicated. The law, if it doesn't prohibit, at least makes it difficult. I know from experience that there are laws around spouses inheriting when their husbands' family bequeath and so on and so forth. And in some sense, you could argue if those are saying you cannot economically discriminate against certain members of the family when you die, well, why should you be able to when you're alive, in some sense, right? So that's just one thought. The other question, which is more really of a question, is around your spectral nature of the distinction between public and private domain, which I thought was interesting. So this is not dichotomous, but kind of a gradual spectral thing. I like that, but then you said it was spectral in the sort of dimension of power. And whilst that, seemed clever, I wonder if it really works. So, for example, think of a procurement process for the purchase of computers for a ministry. But the power asymmetries are not particularly huge. And now think of the relationship between a mother or a father and a baby. To avoid the issues of neglect, let's just think it's about what toys we give them or whether we leave them in front of a TV for hours or not. So I would argue the latter has a much greater imbalance of power than the former, but nonetheless, the former is more public and the latter is more private. So power doesn't quite work for me as the only definition of that.
Thank you. They're both great questions. Let me start with the first one. So it is true that the law does intervene in the family when a certain threshold of harm is met, whether it is gross neglect, whether it is domestic violence. What I'm trying to get at are cases where, so discrimination law is relative, right? The disadvantage is relative rather than absolute. So when the disadvantage does not meet that absolute threshold of gross neglect and domestic violence, but does satisfy a sufficient degree of discriminatory practice requirement. And this is hard because discrimination has never had a de minimis requirement, right? You're not allowed to discriminate between men and women in salaries, even if the difference is 1 pence. Right? So there's never been sort of, discrimination was never required a certain volume of discrimination to kick in. Any distinction makes the law relevant. And I think there's something important about that, even for expressive purposes. And that is the challenge, that discrimination law within the family will go much beyond these very high threshold harm-based interventions. And the question is, to what extent should the law go and in what form? And that is what I'm, I guess, struggling with. Yeah.
Just a quick follow-up on that. My point there on that first part was that the inheritance
Yeah,
law
I'll come to that.
is similar to that in a sense.
Inheritance in some ways is probably the easiest thing to implement because the discriminator is dead. So there's no worry about victimization or enforcement. And I know that some jurisdictions do.
Why do you say that discriminated is dead?
Because
They're alive.
I'm assuming that the inheritance law, the will becomes public and is known only after the person has died, who's mutable, right?
But
Discriminating is the.
discriminating. Okay, discriminating. Okay.
Yeah, the discriminator. Yeah. So that is a good idea, and I don't think in this country there's any requirement that you cannot discriminate in your will and things like that. And I think I would include that is clearly a low-hanging fruit. That you can give everything to your favorite child and exclude your accident, but you can't do it on the grounds of gender. You can't do it to whatever. On the spectral nature of the divide, that's an interesting question. I think in the former case, so I tracked two types of power, right? Not just the relational power differential, but also power two, which is the power that you get not over somebody, but because of your control of resources and your access to opportunities. So your contractor would be within the second notion of power. But I guess what I'm trying to say is that the mother is in a very powerful position over the child and should be seen as maybe occupying, at least to some extent, a public role in relation to that child. And even as I articulated, I know how jarring that sounds, but I think that disjunction is because of our existing moral beliefs rather than my claims.
I think it's really interesting, it makes us think, because in principle, I would also hate to have the state intervene in there, some corner of my mind is like, no, leave the mother and the baby alone. On the other hand, we already accept that the mother or father will have an intervention against them if they don't feed the child for days on end and the child dies. We've seen cases like this. So leaving them in front of the TV unattended for hours on end with no stimulation is a matter of degree.
Yeah.
It's no longer a matter of nature. Yeah. Sorry, Paulo.
Yeah, I'm completely ignorant in terms of.
Didn't stop me, so.
So I was just to say, it's the second question from a qualified part of the audience. So my question relates, it's very general and a little bit philosophical possibly, which is, I see the possibility that some discriminations, some behavior that you could call discriminatory inside the family is a way to reproduce cultural trait and identity. And therefore that preventing this, you are basically discriminating the survival of a lot of diversity. So think, for example, I don't know, I'm unsure about what I'm saying, but think, for example, that Jewish parents that know that becoming Jews depends on your mother, not on your father. So they discriminate in the sense that they don't want their son to marry a non-Jewish, but they are okay with their daughter marrying a non-Jewish. This is discrimination, but this is a way to keep alive their culture, let's say. Another much more from an economist perspective is one of the reasons why there was discrimination in the inheritance, at least in Italy, where I come from, in the passing the land. So the problem is that if you were dividing the land in many pieces, that could become an unsustainable agricultural organization and would have created a lot of problems. So these discriminatory strategies are ways to make organization culture to survive. And what worries me is not that I'm not going to defend any particular of them, but I do see value in the diversity of having many ways of organizing our families, our communities, our tribes, our countries. And so I'm worried that this is a part of the regulation that ends up reducing too much diversities.
Thanks. So this is a general worry about discrimination, or it's not just a worry about discrimination within the family. And the question has come up even in the existing context of state and market in many, many cases. And to frame the question legally, it is a question about the conflict between anti-discrimination law and freedom of religion and culture and beliefs. Right? And whenever these two distinct rights, the rights against discrimination and the right to religion, are in conflict, like all cases of conflict of rights, the courts adopt a proportionality-based approach, which is a case-by-case weighing of the strength of the interests involved and determining which one should prevail and how much. So there's nothing particularly new that the extension of discrimination law to family would require the courts to do that they're not already doing in the context of people running Airbnbs and refusing to rent to same-sex couples. Even the Jewish law question was there's a big case in the UK, the JFS Jewish Faith Louis case, where that was precisely the question. And there are lots of cases there where sometimes the freedom of religion interest has trumped, sometimes the anti-discrimination interest is trumped. And I think that's right. I'm not saying all of those cases have been correctly decided, but I do think that we cannot have an a priori general elevation of one of those interests over the other. But I think my religious interest in how I worship my God or gods is much stronger than my religious interest in what you should eat or how you should dress. So I think our courts know how to do this. And I know that a key part of passing down culture happens within the family. So I can see that there will be more types of cases that would come up. But at least in the high salience types of cases that I'm thinking of extending the regulation to, that I would assume that in such cases the religious interest would be a weak one anyway. So when parents forbid you from relating to another person, or the inheritance question, but where the line should be drawn, I think is a tough one, and I'm not sure there is a general line that can be drawn. It depends. I mean, sometimes a religious practice can be extremely critical to the religion and be awful, right? So, I mean, many religions have had terrible historical practices, like the widow burning practice in India. So what discrimination law does not do is to, except in the US has gone to a stage now where the religious interest has an a priori presumptive superiority over the anti-discrimination interest. But in all other jurisdictions, it's a question of balancing rather than a generic priority.
Great. So, I'm afraid we'll have to take those up over coffee or something, because unless the person who was typing has finished typing on.
Oh, yes, let's see.
Take that last one, because it interrupted it, and then we'll close.
It's just very kind and more praise.
So we're very grateful for the praise of the colleague online, and particularly we're grateful to you, Tarun, for the seminar. So thank you very much.
Thank you.